then 19.271.6 is a statute for use by the defense. And I'm going to ask Alex, have you used the statute? How do you foresee how it's going to be used in the future?
Thank you for allowing me to be here today. Let me tell everyone that this is a game changer. I think that this statute completely changes what you can do. It overrules Stamper versus the Commonwealth, which prevented you from introducing mental health evidence in the guilt innocence phase. It, for the first time, allows you to, and the statute says that it is relevant and admissible evidence that tends to show that the defendant did not have the intent required for the crime charge. So what does that do? Well, that opens the door for any evidence regarding mental illness that significantly impairs judgment, intellectual and developmental disabilities, as well as the autism spectrum disorder. We were never able to do this before. And it is a critical change, but what I would warn practitioners is that they need to read the statute and then read it again and then come up with a plan because there's a lot packed into this statute. And because it's new, there's some uncertainty in terms of its application. But you have to watch out for notice requirements. Got to give 60 days notice if you're using it in circuit court. You got to give 21 days notice to the Commonwealth if you're using it in general district court. You have to make decisions about, do you need an expert witness or not? Do you need to ask the court for funding for an expert witness or not? You need to figure out what kind of evidence you need to prove that your client is autistic, developmentally disabled, whatever the case may be. What evidence do you need? How do you get around hearsay objections? How do you get around foundation objections? It's a criminal case, right? So your expert can't simply say, I relied on A, B, C, and D, and then introduce hearsay testimony. The prosecutor's going to object to that. But I was speaking to the judges before, and this statute is not being used in the Commonwealth, despite its existence now for some time. It is rarely being used. I used it in a 3-day jury trial recently this spring. I used it in a pardon petition because my autistic client didn't have the benefit of this statute when he was prosecuted. But it is not, I've spoken to many judges about this, and it is not being used as often as I would have expected. And I'm surprised by it, frankly. And let me tell you a couple reasons why. As the judge mentioned in the general district court, you rarely, if ever, have a not guilty by reason of insanity defense. And the main reasons for that are timing and consequences. So if I have a client who's incarcerated on a misdemeanor, am I going to play God and do an NGRI defense that's going to keep him or her in jail while the evaluations are being done, while the mental health, the court-appointed mental health experts asking for an extension, while the Commonwealth gets to have their own evaluation done? And then if we prevail, the person goes to the custody of the commissioner. I'm probably not going to do that on a misdemeanor case. That's a tough decision. Here, it's totally different. Here, the model jury instruction that was created for this new statute, 53.170, instructs jurors to find the defendant not guilty if they have a reasonable doubt about whether the defendant possessed the intent for the crime charge. So what does that mean? That means that we're now, instead of having a presumption of sanity, like we would in an NGRI defense, we have a new statute that says if you have reasonable doubt that the condition caused a disconnect with regards to criminal intent, then you should find him or her not guilty. That means they don't go to the commissioner, the custody of the commissioner, they go hopefully into an inpatient or outpatient program, and hopefully they have family support, and hopefully, we're going to start playing multiple roles as attorneys in coming up with a good transition. But the difference in what happens and the difference in how long it takes to happen is huge, and it's just night and day. And that's why I think General District Court is going to see the most change once attorneys become aware of this statute. But it can also be utilized effectively in circuit court. And the other reason why I think that people need to look at this statute and think about using it more often is, what is mental health evidence? What is evidence about autism spectrum disorder, developmental disability? It's really not just guilt or innocence now, but it's also mitigation evidence, right? So we always used it as mitigation evidence. We always wanted to use it in our sentencing hearings, in our bond hearings, but now we get to front load it. And if any of you have done capital cases, we talked a lot about front loading mitigation, getting mitigation out there from the beginning. And this is a way to do it. And there's really no downside. I had one of the rare cases where the mental illness was somewhat explosive and scary to jurors. But you can use the new bifurcated trial statutes that you have now available to you, so that you can have a jury decide guilt or innocence, and then still have the judge as the backstop in terms of what the ultimate penalty should be, because they may understand the condition better. So that's just a couple of initial points that I'd like to make, and we'll get into some more of the details